Salutations to all our future judges. In this video, we are going to see Indian Evidence Act 1872. But before going into the video, I'd like to make few requests to our viewers as well as the subscribers. Kindly do not skip the video. Watch the video from the beginning till the end. If you skip in between, you may be missing very crucial information or very crucial aspects which have been explained. Hence, watch from the beginning till the end. And next request is, please do have a notebook and a pen with you, because various questions which have been asked in Evidence Act in various exams would be mentioned or would be stated. And in addition to this, idea would be given as to how questions could be framed in a particular section. It is very important for you. So you all need to make a note of all these aspects. And in addition to this, some additional illustrations would also be given while teaching the act. Hence, you please make a note of all those additional illustrations as well. They would be of absolute help to you in understanding the particular section. And in addition to this, various ways or techniques would be taught which would help you to remember those sections, or to say some memory techniques would be given. This would be really helpful to you in remembering the sections when you go to the exam. I hope this video would be of absolute and great utility to you. Section 33. Relevancy of certain evidence for proving in subsequent proceeding the truth of facts therein stated. So, let us try to understand this in a simple manner. Imagine there is case 1 where A and B are the parties. Now, let us move to next scenario, case 2, where the same A and B are parties. There are two cases where there are the same parties, and both the cases have the same question in issue. This is very important. Please understand this fact from the right perspective. Now, in case 1, there is a person who is giving witness, who is giving evidence. Now, whether that evidence which is given by a witness in the case 1 can be used in case 2. That is the point we need to ascertain. This was once asked in the main exam of civil judge conducted by the Tamil Nadu Public Service Commission. This question, this particular section was asked. So please try to understand this concept. It's very important. Even if you are an advocate for practicing, this would be of great help. Now, that person who gave witness in case 1 is dead, or he cannot be found, or he has become incapable of giving evidence, or the opposite party is trying to prevent him from coming to the court, or if this witness has to come, it would be of extreme delay and it would be very expensive. In all these circumstances where the court is considering it to be unreasonable, in all these circumstances, the evidence given by the witness in case 1 can be used in case 2, provided the parties in case 1 and case 2 are the same parties, or their representatives can also be there. And in the first case, the adverse party, that is the opposite party in the first proceeding, had right to cross-examine that witness. That is very important. And another aspect is, the first and second proceeding should have the same questions in issue. This is very important. Party should be same, question in issue should be the same. And they are given an explanation. Sometimes questions could be asked even from this explanation. So what is a criminal trial? They might ask a question. So criminal trial or inquiry is deemed to be a proceeding between prosecutor. Here the prosecutor means one who prosecutes. Simple, the case. And the accused within the meaning of this section. So criminal trial means between prosecutor and accused. That is called as criminal trial or inquiry. That has been explained in section 33. Section 34, entry in books of account when relevant. The entries in the books are relevant if the court has to inquire into that particular matter, when they refer to a matter into which the court has to inquire. Imagine there is some dispute with respect to the accounts and the case is pending in the court. In that case, it is relevant. The entry in the books of account is relevant, but that is not sufficient to charge any person with liability. They have to prove additional evidences, and that is also necessary for proving the case of the person who has made a claim. Let us see the illustration. A sues B for ₹1,000 and shows entries in his account books. So, this A is filing a case against B, saying that B has to give me ₹1,000, and he is showing in the court his books of accounts, saying that B is indebted to him. But these entries are relevant, but only with this he cannot prove the case against B. So, he should provide other evidences to prove the debt. Let us move to section 35. Let us try to understand this section 35 with an example. Now, the question in a case is whether a person has handed over or submitted a document or a receipt to the government. So, in that case, if there is an entry made by a public officer in a register where it is registered that so and so person has handed over the receipt or the document to the government. So, in that case, while this person who has recorded it is doing it in his official capacity, or there is any other person who is authorized by law to do this, he is registering this, saying that so and so person has handed over the document or receipt on particular date. That is recorded in the register, and that itself is a relevant fact because it is connected to the fact in issue or the relevant fact. Let us move to section 36. Relevancy of facts, relevancy of statements in maps, charts and plans. Let us try to understand this section 36 in a simple way. Now, there is a case pending in the court where the question is whether there is a particular building in a particular road. Now, there is a map or there is a chart which is being sold under the authority of the central government or any state government, or the map is made under the authority given by the central government or state government. That map shows that there is a building in that particular place, so that can be considered as a relevant fact. But the important thing is the map or plan should be made under the authority of the central government or any state government. That is very important. Now, let us move to section 37. Let us try to understand this section 37. Relevancy of statement as to fact of public nature contained in certain acts or notifications. Imagine a scenario where the court is facing a question pertaining to a public nature. The court has to decide any fact pertaining to a public nature. Now the court is confused as to what it can do. Then in that case, if there are certain aspects of these public nature in the recital contained in any act of the parliament. Imagine an act says something about this fact which is in dispute. Act of Parliament of the United Kingdom, or in any central act or provincial act or a state act, or in a government notification or notification by the crown representative appearing in the official gazette or in any printed paper purporting to be the London Gazette or the government gazette of any dominion, colony or possession of His Majesty is a relevant fact. So, if any government notification contains this, including the Act of Parliament of the United Kingdom as well as the Crown Representative. So, it is not just pertaining to India, it is also pertaining to the Act of Parliament of the United Kingdom. That is also equally relevant. So, in all these cases, if that particular fact of public nature, something is mentioned about that or some statement is there pertaining to this fact of public nature, then that is considered to be relevant. Let us move to section 38. This particular section, section 38, speaks of relevancy of statements as to any law contained in law books. Now, let us try to understand this with a simple example. Now, the court is facing a question. The court is trying to understand what that particular law, imagine the law of United States of America. So, in that case, any law book published by the government or under the authority of the government, US government, in that case, the court can refer to that law book and identify or try to form an opinion about the law of United States. Then, they can even refer to the ruling of the courts in United States of America. Simply, A court can refer to law books or the judgment given by a foreign court or a foreign law from the books, law books published by the government or published under the authority of the government. How much of a statement is to be proved? Section 39. What evidence to be given when statement forms part of a conversation, document, electronic record, books or series of letters or papers? Now let us try to imagine the scenario. A person has given a statement and that is in a book. It's a very huge and voluminous book. Then, to what extent that statement can be proved? The court is clearly saying this, that if that particular statement forms part of a longer statement or of a conversation or part of an isolated document or is contained in a document which forms part of a book or is contained in part of electronic record or of a connected series of letters or papers, evidence shall be given of so much. So let us try to understand this in a very simple manner by way of an example. There is a letter or there is a series of letters. Imagine there is a person who is writing letters frequently or he is sending emails regularly. There are, say, some 10,000 emails. So in that case, the court cannot see all the 10,000 emails. So what they do is the court will try to understand the concept and the effect of that statement and circumstances based on which it is made, and to that extent whatever is required it will take. Now let us see what the section in this regard particularly says. So, as the court considers necessary in that particular case to the full understanding of nature. So, the court is trying to understand the nature of the statement and the effect of the statement and also circumstances under which the statement was made. So, to put it in a simple manner, the court will try to understand the nature, effect of the statement as well as the circumstances under which the statement was made. To understand all these aspects, whatever is required, only that part will be taken from those 10,000 emails. They will not read all the 10,000 emails. They will take only relevant portions, which would help the court to understand the nature, effect of the statement as well as the circumstances under which it was made. I hope you would have liked the video. If you like the video, please do press the thumbs up button and do share the video with your friends and motivate them. If you are not subscribed the channel, please do subscribe the channel and share the channel with your friends. If you feel that I've left something in this video or you want me to change the way in explanations are given for the sections, please do let me know by way of comments. Let us join hands together and contribute for a learned society. Thank you.